On the 6th of April, 1933, the main office for press and propaganda of the German Student Association proclaimed a nationwide action against the un-German spirit, which was to climax in a literary purge or cleansing by fire. 1 month and 4 days later, on May 10th, 1933, over 25,000 volumes of un-German books were ritualistically incinerated, signifying the establishment of an era of state control and state censorship and cultural control. Today, a similar travesty is occurring. According to SchoolLibraryJournal.com, there are more than 56 organizations in the United States with the intent of banning literature they find unsuitable and limiting student access to such literature, thereby repudiating government-established natural rights. My major claim is banning books in the United States denies students their legal rights. My supporting claims are: 1, banning books directly violates Article 19 of the Universal Declaration of Human Rights. 2, banning books violates the American Library Association's first policy of their Bill of Rights. And 3rd, banning books violates the First Amendment of the United States Constitution. As a matter of clarification, the term legal rights, as defined by Stanford Encyclopedia of Philosophy, is simply rights which exist under the rules of a given legal system. So to go into my first point, banning books directly violates Article 19 of the Universal Declaration of Human Rights. That declaration was adopted by the United Nations General Assembly and represents the first global expression of rights to which all human beings are inherently entitled. As I'm sure we're all familiar, the United Nations is an organization which was founded in 1945 whose stated aims are to facilitate social progress, human rights, and the achievement of world peace. All of us U.S. citizens are all protected by this Declaration of Rights. The 19th article reads, "Everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media, regardless of frontiers. Furthermore, the act of censoring one's ability to receive nonpartisan information and creating a canon of pre-approved material is an act of propaganda." Propaganda, as defined by Merriam-Webster Online Dictionary, as ideas, facts, or allegations spread deliberately to further one's cause. In 1972, there was a court case which dealt with such a thing. It was Todd versus Rochester Community Schools. And in deciding that Slaughterhouse-Five, Kurt Vonnegut's novel, could not be banned from the libraries and classrooms of the Michigan schools, the Court of Appeals of Michigan declared, and this is the original stenographer's note, "Vonnegut's literary dwelling on war, religion, death, government, politics, and any other subject should be as welcome in the public schools of this state as those of Chaucer, Shakespeare, Melville, or Walt Disney. The students of Michigan are free to make of Slaughterhouse-Five what they will." So we see that the education system does not have the power to decide whose opinion is more valid solely on the basis that one is more conservatively recognizable than the other. My second point is banning books violates the American Library Association's first policy of their Bill of Rights. The American Library Association, or the ALA, is an organization founded in 1876 which regulates national libraries in order to provide leadership for the development of information services and to enhance learning and ensure access to information for all. And they're closely connected with the education system, so it's disturbing that such education systems disregard their policies. The first policy reads, "Books and other library resources should be provided for the interest, information, and enlightenment of all people of the community the library serves. Materials should not be excluded because of their origin, background, or views of those contributing to their creation." It continues on to discuss something called intellectual freedom, which is the right of every individual to both seek and receive information from all point of views without restriction. So by abridging the students' freedom of literary investigation, their education becomes superficial and is limited. My third and last point is, banning books violates the First Amendment of the U.S. Constitution, which in part discusses freedom of speech and the freedom of the press. Freedom of speech is the freedom to speak freely without censorship or limitation, and the freedom of the press is the freedom of communication and expression through vehicles including various electronic media and published materials. In 2003, there was a major court discussion of Counts versus Cedarville School District, who attempted to get the Harry Potter books banned because of unsavory material. The district court overturned the board's decision and ordered that the books be returned to unrestricted circulation on the grounds that the restrictions violated students' First Amendment rights to read and receive information. So the education system is still bound by the Bill of Rights and could not abridge students' First Amendment rights to read a book on the basis of an undifferentiated fear of disturbance or because the board disagreed with the ideas contained in the book. So the act of banning books is in complete opposition to the Universal Declaration of Human Rights, ALA Bill of Rights, and the U.S. Constitution. So by denying students the freedom and resources to openly explore at their own discretion the historical literary canon, by radically banning books, United States students are being denied the very rights which have come to define this nation.
All right, Eric, I like the opening. I thought it set up the controversy a little bit. I think you need a little bit more information, though, on the nature of these organizations that you're talking about that are pursuing what you've described as a ban on books, or what the Library Association describes as a ban on books, because that's where the controversy really is. I don't think that there's much dispute. I mean, you show that there's not much dispute based on the UN Declaration of Rights, the First Amendment, and the Library Association's own criteria that access to these is appropriate. The question is whether or not the books that are in fact being challenged by these groups fit those criteria and therefore deserve to be protected or are protected under the rules that you're talking about. And that's why I think you need to have something more than a case from 40 years ago and the Harry Potter case. Those are the only two cases that you really specify where these kinds of things are going on. The Harry Potter case being the more recent one, I think, is the one that applies best to the issue that you're talking about. Otherwise, like I said, you've mentioned 56 organizations. Well, what kinds of restrictions are they trying to apply? What kinds of limits are they putting on? What books in particular are they talking about? Because as long as the books fall into the purview of the subject matter that you're talking about, then they should be protected. There's got to be some justification on their part that explains why there's a controversy on this point. And so I think that needs to be developed a little bit more. The internal signposting is very good. I thought that the presentation is solid. The language is very clear and easy to follow for the most part. You have good internal transitions, and the labeling of the points is good. I thought you had good citation of evidence on the court cases that you talked about and explanations of what the criteria were from the UN and from the Library Association as well. So I think we're in pretty good shape on those points. Like I said, it's the particulars that I think create the problems here rather than the generalizations. And the generalizations, I'm not sure that's where your argument is. Your argument is really more about the particulars. All right, thank you.